Hi, I'm Joel Beck, an estate planning and probate attorney with Peach State Wills and Trust in Lawrenceville, Georgia. And if you own real estate here in Georgia with your spouse, there's two things that you need to particularly be aware of because we're seeing some problems with this lately. We're seeing two problems relating to real estate deeds that are causing a lot of headaches for people in Georgia. If you own real estate with a spouse, you need to be aware and be mindful of this. First, there's two different ways that spouses can own real estate together. They can own it as joint tenants with right of survivorship. And if that's the way it is, then when one spouse dies, the other one owns it all automatically. But to hold property as joint tenants with right of survivorship, your real estate deed must specifically state that you own it as joint tenants with right of survivorship or joint tenants. Otherwise, the property will be deemed to be held as tenants in common, TIC, what we call TIC. And if the property is held as TIC, it means that when one spouse dies, the house is going to have to go through probate to be able to transfer the deceased spouse's interest in the house to his or her beneficiaries under the will, or if there is no will, to his or her heirs at law. So having a deed that provides for joint tenants means that no probate is necessary for the house to be fully owned and therefore be able to be fully managed by the surviving spouse when one spouse dies. Now, that in some very old deeds, it may say words to the effect that the parties own the property as tenants in common for and during their joint lives, and upon the death of either of them, then to the survivor of them in fee simple. Well, if there's a deed with that language in such situations, Georgia courts have said it's not a true joint tenancy, but it essentially has the same effect. After one spouse dies, the other spouse owns it. We see that language really from the early 70s and before. So your first takeaway is to check your deed. If you intend that the property go to the surviving spouse outside of probate, make sure that you own it as joint tenants with right of survivorship. Recently, when working with clients, we found that many people believed that they held the property as joint tenants, but they do not. And this seems to be much more prevalent when they had purchased the property in the 1970s through the 1990s, as opposed to much more recent. Now, the second problem we're seeing is that you've got a married couple who owned their house as tenants in common. It wasn't a joint tenants deed, but there was never a probate after the first spouse died. So when the second spouse then comes and wants to sell the property to move somewhere else, or maybe they need to raise money to go to assisted living or a nursing home, for example, they can't do it immediately because the surviving spouse does not own and control all of the house, because as tenants in common, the deceased spouse's estate has an ownership interest and that estate had never been probated. Or we see a situation arise where the second spouse has died and the family comes to find out that instead of probating just one estate, they have to do two probates. And so that's going to add to the cost and definitely add to the time to get things squared away. So your second takeaway is that if you owned a house with a spouse who has died, check the deed, make sure that you owned it together as joint tenants. If not, speak with a lawyer about whether there needs to be a probate case started for that deceased spouse. Now, for more information about estate planning or about probate, I invite you to visit us online at peachstatewills.com. Thanks.